Well, Scotiabank, RBC, and BMO have all announced plans in the last few months to cut their workforce by 2 to 3%. That's about 6,000 workers so far that are all looking for new jobs. Banking is a federally regulated industry, but does that affect severance and other dismissal factors? Employment lawyer Alex Lucifero joins us now with more on this. I guess, Alex, first of all, take us through the difference between a federally regulated and provincially regulated employee.
It's a question that we get asked as employment lawyers quite often, Matt, although the reality is there isn't much of a difference. So in Canada and across the provinces, there are certain employers, certain industries that are federally regulated. In other words, they're governed by the federal government of Canada and specifically the Canada Labour Code, which is the piece of legislation that governs minimum employment standards. So things like minimum wage, vacations, minimum or maximum hours of work. And those industries, Matt, are banking, telecommunications, air transportation, intra-provincial road transportation, to name a few. Those are the major ones. Again, the reality is there isn't much of a difference between provincially regulated employers, which is every other industry that we can think of, really, and those federally regulated employers, except for one, and that does come with termination of employment.
Okay, so let's talk about that too. And again, termination in particular, I know the number of people, clearly hundreds of people dealing with this. Can an employer terminate a federally regulated employee without a reason?
Yeah, so here is the one distinction between federally regulated and provincially regulated employees. When it comes to a federally regulated employer, Matt, again, we could talk about the big banks, telecommunication companies, et cetera. The employer has to have a reason for termination, Matt. They cannot terminate an employee without cause for no reason at all. There needs to be some sort of justification. So that could be either a downsizing or a restructuring, as we've seen with the banks in this particular case, or it could be perhaps performance related or conduct related, but there needs to be a reason. For provincially regulated employees, kind of oppositely, you don't need a reason to let an employee go. It could be for no reason at all. You can let that employee go without cause. Of course, those employees would be owed severance in the circumstance.
And let's just touch on severance. So you need a reason in order to terminate an employee who is federally regulated, but are there differences in severance, or how does that work if they're let go?
Yeah, so severance is a great example of the following, but it can apply to lots of other employment protections and laws and principles, Matt. There is no such distinction when it comes to calculating severance between provincially and federally regulated employers. Severance is going to be based for all of these employees, including employees of banks, based on their age, position, and years of service. The older you are, the more senior your position, the longer you've been with the same company, the more severance you're going to get. Severance for any of these employees could be as much as 24 months, potentially.
Right. Always some good information. Alex Lucifero, appreciate your time today. Thank you, sir.
Always a pleasure, man.